welcome to Crime in Court. My name is Heather, and this is an update in the Sarah Boone case. So, you may have already heard, she is her ninth lawyer. So, she has gone through 8 public defenders, and we're going to read why the judge thinks that she should represent herself at trial. So, as you can see, I have her as the lawyer and the witness in the thumbnail, which I just thought was funny. So I hope you enjoyed that. Anyways, let's get to this. So, please hit that like button and let's dive in. So this was filed Friday afternoon and it comes from the judge. This cause came before the court on June 28th, 2024, on defense counsel Patricia A. Cashman's Esquire motion to withdraw as counsel, filed June 11th, 2024. So, in that first sentence, you can already tell Sarah Boone's lawyer, who is Patricia A. Cashman, filed a motion to withdraw. She didn't want to be Sarah's lawyer anymore. So let's find out why. That was filed June 11th, and the court is going to grant it. So the court, having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, having considered the positions offered by counsel Patricia A. Cashman, Esquire, having considered the testimony offered by defendant Sarah Boone, and having considered the positions offered by counsel for state, hereby finds A. On March 23rd, 2020, by way of information, the defendant was charged with second-degree homicide. Procedural history. B. On February 26th, 2020, the Office of the Public Defender, 9th Judicial Circuit, in and for Orange County, Florida, the public defender and attorney number 1, was appointed to represent defendant. C. On March 9th, 2020, the public defender moved to withdraw due to defendant retaining private counsel, to wit, Maurizio Padilla, I don't know if I'm saying that right, Esquire from Padilla Law Group. That was lawyer number 2. So first one was public defender assigned to her, then that one withdrew because she hired personal private counsel. D. On March 11th, 2020, the certain order allowing withdrawal was entered, which withdrew the public defender from further representation of the defendant. E. On April 18th, so about a month later, Padilla moved to withdraw due to irreconcilable differences arising. Oh no, I'm sorry, that's 2 years late. Wait. Yeah, okay. That's 2 years later, sorry. Look at the year. Hold on 1 second. All right, so on April 18th, 2022, Padilla moved to withdraw due to irreconcilable differences arising between undersigned and the defendant to have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the court. This position was served upon the defendant, and the defendant confirmed receipt. See letter dated April 20th, 2022, and filed on April 26th. So, irreconcilable differences on lawyer number 2. F. On April 29th, 2022, a hearing was held on Padilla's motion to withdraw. At the time of this hearing, Padilla had been representing defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from the defendant, a letter dated April 20th, 2022, and filed on April 26th, 2022, which seemingly objected to Padilla's withdrawal. She didn't want her to go, or him. She didn't want to lose her second lawyer. but he had irreconcilable differences. So the court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable differences. Padilla requested an opportunity to amend the motion to address the irreconcilable differences. He's like, "Oh hell no, I ain't going back." He said, so Padilla requested an opportunity to amend the motion and address the irreconcilable differences. He's like, I am not. He could either do that or he could withdraw the motion. He's like, nah, I can't spend another second with Tara. The court reserved ruling on Padilla's motion to withdraw, gave Padilla until May 3rd to prepare and file an amended motion with a hearing to be heard on the week of May 9th. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. Defendant testified to a lack of trust between herself and Padilla. G. On May 4th, 2022, Padilla filed an amended motion to withdraw, which supplemented the original grounds. This footnote number 1 says the same irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult, so we already heard this within the motion. It's difficult to convey all particulars to the court and at the same time maintain all duties to the client. Grounds were included. So they can't totally tell on their client and they can't tell everything that's going on to the court because it would violate that client attorney privilege. So I can only give you as much as I can, but I'm telling you, we have irreconcilable differences. Um, all right, so here are the original grounds. Undersigned's undersigned's relationship with defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. And 2, undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client and, as such, will stand mute on the specifics. So this almost makes it seem like he knows something about her past, or he has something regarding specifics about this case, and he and his client probably wants a different strategy, and maybe for him not to disclose certain things that he knows and to lie or overlook certain things, because that could be a factor. Maybe ethically I can't do what this client is asking me to do, could be a major factor. So remember, we're still on attorney number 2. All right, so H. On May 6th, 2022, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds. All right, so it's the same irreconcilable differences arising between undersigned and the defendant that have made it impossible for the undersigned to effectively represent his client. This is his amended language. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client, and undersigned's relationship with the defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial, where were grounds included. All right, so here are the supplemental original grounds for his second motion, which was filed May 6th. 1, undersigned's relationship with the defendant has deteriorated to a point where undersigned's counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. That's interesting. I like the way he worded it. The relationship with the defendant has deteriorated to the point he can no longer be effective and fair. He's probably like, I am done with this woman, and if she asks me to go to court for her, I don't want to do it. I can't, I can't, in good conscience and with self-respect, do what she's asking me to do. So this motion, I'm speculating on that, but that's what I would think these guys are going through. All right, so this motion is in compliance with the Florida R. Jude, whatever, a bunch of rules from the Florida bar are present, or whether the attorney-client relation has deteriorated to a point where counsel can no longer give effective aid in the fair representation of a defense. That was Sandburn that they were quoting. On May 10th, 2022, a hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. And that right there, ethical concerns, makes me think she was asking him to overlook something or to lie for her about something or to go about something the wrong way, which so I have heard, she's trying to go with this like battered wife syndrome or whatever it's called nowadays. I don't know the technical term, but she's going with that, excuse. I don't I'm not going to say it's an excuse. Maybe it's true, but she's using that as her defense. However, I heard also that she has prior um DV incidents, not necessarily with Jose, but with other individuals, maybe. I don't know. I cannot confirm or deny, but that's something that I saw out there on the interwebs. So if she is going for this battered wife defense and she has other incidents of DV in her past, they're going to dig that up. So a lawyer might be like, it's suicide to go. Oh, I shouldn't say that word. It's legal trial self-deletion if you go that route is what he might be saying. So yeah, I think there might have been some ethical concerns with some of these. I mean, obviously, we had some ethical concerns with Padilla. So let's see. He's still attorney number two. By the way, I want to say this is well written by this judge because he thought this through. This is not something that a judge would just do because to put a an individual out there and to take away counsel from them is incredibly, I want to say rare, but it also like there's a very high standard that you have to meet in order to get there. And I think going through 8 attorneys, maybe that is the threshold. Not sure, but here in Florida, that's the threshold. All right, so ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. So by this time now, well, first she objected to it, but at this time, she's ready to get rid of him. The state expressed concern of a strategy to allow defense attorney after attorney to represent the defendant. So the state had a concern about her going through attorneys already on number two. So that's interesting. The court advised defendant of the state's concern regarding the strategy of defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. So they were warned, she was warned, Sarah Boone was warned about self-representation back when uh, lawyer number two was withdrawing from her case. The court then appointed public defender number three. J. On June 6, 2022, the public defender moved to withdraw due to a conflict. So May 10th to June 6th, Not really her fault if there is a potential conflict between the two. Maybe the public defender knows someone that knows Sarah, or who knows, whatever that concern might have been, they were conflicted off the case. So just ethically, that's what you got to do. So by June 7th, this, that certain order allowing public defender withdrawal was entered, which withdrew the public defender from further representation of the defendant and appointed the Office of Criminal Conflict and Civil Regional Counsel, or the RCC, and attorney number 4. What is the Office of Criminal Conflict and Civil Regional Counsel? Hmm, interesting. I wonder what that is. If it's like someone to help mediate, maybe? Hold on one second. All right, I'm back. So this is from their website about the Office of Criminal Conflict and Civil Regional Counsel. The 5 regional counsel offices were created by the legislature in 2007 to provide legal representation to indigent persons in basically 3 classes of cases. Sorry, my nose itches. Criminal conflict cases that the court grants the public defender's motion to withdraw and appoints this organization. Uh, Dependency and civil cases, and certain statutorily authorized civil commitment proceedings. So it is a council created by legislature to help provide legal representation to individuals who can't afford it for themselves. Oh my god, my leg is so asleep right now because my dog is on it. I have no feeling in my right foot. Hold on one second. Okay. So yeah, it's just it's a council for individuals who need legal representation and can't afford it. All right, so back to where we were. All right, so L, on June 10th, 2022, RCC moved to withdraw due to a conflict. Okay, so another conflict. Attorney number 4. We've got 2 conflicts, 1 irreconcilable differences, and another, what was it? Irreconcilable differences. What was attorney number 1? Oh, she hired her own. So that was, I mean, that's not really bad. She hired her own, so the other one withdrew. All right. Um, so due to a conflict, they want to withdraw. On June 7th, that certain order allowing public defender withdrawal was entered, which withdrew the public defender from further representation of the defendant and appointed the Office of Criminal Conflict and Civil Regional Counsel. So they went. Oh, I didn't go. Hold on. Did I read that already? Yes, and that person wanted to be removed. I scrolled up and down and I confused myself. All right. So RCC wanted to be withdrawn from the case on June 22nd. The certain order allowing the Office of Criminal Conflict and Civil Regional Counsel withdraw was entered, which withdrew the RCC from further representation of the defendant and appointed Mark Consolo, which was, and attorney number 5. It says and attorney number 5. So is it 2 people? On July 8th, 2022, the Consolo moved to withdraw the Consolo? I don't know. That must be an error. Consolo moved to withdraw due to a conflict. So another conflict. Conflict of interest could be anything. Maybe, uh, I don't know. I don't know what, like if there's, maybe it's just a way of saying, I don't want to work with her. Could they be using conflict of interest? Like, oh yeah, I know her second cousin from another mother. I don't know. All right. Oh, On July 11th, 2022, that certain withdrawal order was entered with which withdrew, sorry, was entered, which withdrew Consalo from further representation of the defendant and appointed Frank J. Bankowitz in attorney number 6. The certain order substituting conflict counsel entered October 25th also appointed Bankowitz as counsel for the defendant. P. On July 12th, 2022, Bankowitz in open court requested a continuance due to his recent appointment and same was granted. Thereafter, the court set a pretrial conference for October 25th at 9 a.m. and during during the trial period beginning November 7th of 2022. On October 25th, the court held the pretrial conference and addressed the court's understanding that a continuance was being sought and the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. On October 27th, Bankowitz filed defendant's motion to continue. On October 28th, the court entered that certain amended order on defendant's stipulated motion to continue, which set a pretrial conference for January 17th, 2023 at 9 a.m. and trial during the trial period beginning January 30th. On November 22nd, the court set a status hearing on Tuesday, December 20th at 10:45 a.m. On December 19th, 2022, Bankowitz moved to withdraw due to the irreconcilable differences which have arisen between the undersigned, his client, and his family. The undersigned, his family. Okay, sorry, that threw me. Let's start again. On December 19th, Bankowitz moved to withdraw due to the irreconcilable differences which have arisen between the undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant. Was she threatening the family? Like how did the attorney's family get involved in this? So it's arisen between the undersigned, so Bankowitz and his client, Sarah Boone, and his family. So something about his family is a conflict and irreconcilable differences going on there. It's very curious. All right, V. On December 20th, 2022, the status hearing was held. Bankowitz did not appear due to a car accident, and the court reset the status hearing for December 22nd, 2022 at 11 a.m. W. On December 22nd, 2022, the reset status hearing was held. Bankowitz appeared virtually, and due to technological issues, Bankowitz was unable to hear the court. The court reset the status hearing for December 27th, 2022. X. On December 27th, 2022, a hearing was held on Bankowitz's motion to withdraw. Defendant was present from the hearing and was sworn. The court advised defendant that the court had received letters from defendant, a letter dated October 3rd, 2022, and filed on October 7th, a letter dated November 3rd, and filed November 7th. And one attacks the November 3rd letter attacks Bankowitz's professionalism. The December 5th letter attacks Bankowitz, including severely mislead and neglect. So those are words that she's used. He severely misled me and neglected me, is what she's saying. And it appears that she really is very high maintenance with her lawyers, wanting them to talk to her quite a bit. All right. The court conducted a Nelson hearing, and defendant was not seeking to remove Bankowitz. Bankowitz advised even though she's called him unprofessional and that he misled her and neglected her, she still wanted him on the case. Probably because she knew trial was coming up. Maybe she's doing this all intentionally to drag it out more. Who knows? The court conducted a Nelson hearing, and the defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the thousands of pages in discovery that he had reviewed and organized, and his contact and potential use of and collaboration with expert witnesses, including experts that Padilla, attorney number 2, utilized. So this attorney, which is what, 5 now? I lost count. I think he's 5. Shoot. Where'd he go? I don't know. I think we're on 5. Okay, sorry. Bankowitz advised the court of defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day. I would keep my phone on silent all day. Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. If I'm talking to my client 5 to 10 times a day, how can I serve any other client at this point in time? In response, defendant reposted or reposited, sorry, that no, I don't know what this word is. Reposted? Right. Hold on. All right, the definition is it's pronounced repost or reposted, and it is to make a quick, clever reply to an insult or criticism. So in response, defendant reposted that Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands for lack of communication, alleged Bankowitz's action in this case rose to the similar level, and then sought to remove Bankowitz. The court pointed out that the defendant's inconsistent statements within minutes of them being made and addressed concerns over defendant's motivations, especially when there is something defendant disagreed with. The court specifically advised defendant that she is not entitled to an endless line of court-appointed lawyers until you find the one that you personally prefer. The court also explained, so this is number 5, I think, and the judge is again letting her know you can't just keep going through all these attorneys. Some of them haven't been her fault, apparently. Although they could maybe just be saying that it's a conflict, even if it's just like irreconcilable differences or something. I don't know. Maybe that was their way to get out of it. The court has explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with defendant prior to the pretrial conference previously set for January 17th last year. Why? The case was continued several times due to Bankowitz's attempts to retain an expert through JAC and JAC's response time, or response to same. What was it? Motion for appointment? 6. Yeah, the JAC. See also defendant's quasi ex parte motion for appointment of defense forensic psychologist. Okay, these are just other things that they filed, but it's saying to also reference. Letter Z. During this time period, the court has received several letters from the defendant, a letter dated January 10th, 2023, and filed on the 17th, a letter dated the 22nd, and filed on the 14th, a letter dated the 6th, and filed on the 14th. Of April, sorry, a letter dated May 15th and filed on May 18th, a letter dated June 29th and filed on July 21st, and finally a letter dated August 2nd, filed on the 7th. What do these say? again, attacking his professionalism and morals. Da, 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 da. Oh, this one alleges that Judge Wayne C. Wooten was being monetarily compensated from third parties' use of information that is publicly available. What? So she was blaming Judge Wooten for something? She does have a new judge now, so I wonder if that she's got Kranick now. But it used to be Wooten, so at some point in time it must have changed. So the January 29th letter says attacks on Padilla, which were not raised during any of their hearings. Are there more? No, that was it. Okay. At least stupid footnotes. All right, where were we? Letter AA. On August 22nd, 2023, Bankowitz again moved to withdraw due to one, irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particular matters and the same, okay, and maintain all duties to the client. So basically, same language. Two, the defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone's case. It does appear that way because it does seem like 5 to 10 days, 5 to 10 calls per day. She seems really needy. She seems with these letters like she really has stuff to say. She wants to be heard. She's not happy. She's gonna complain about whatever's bothering her, and she wants somebody to hear her. She wants an audience. Number three, the best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. And this is coming from Bankowitz, who has been forced now to stay on even longer. He continued the case. Tried to leave. Judge said no. Waited out some more. He went back, and now he's asking again to be with to be able to withdraw from this case. Letter BB. On September 8th, 2023, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. Bankowitz addressed defendant's derogatory statements, calling him a dud and a buffoon and berating behavior. The court advised defendant that the court had received letters from defendant, a letter dated August 26, 2023, and filed on September 7th, and a letter dated August 30th, filed on the 7th. Oh, we don't have any footnotes. After the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal, the court granted Bankowitz with motion to withdraw and appointed Winston Hobson as attorney number 7. Oh, I'm sorry, we were on attorney 6. So now we're on attorney 7. That's right, because there was an extra one in there. I lost count. It's so hard to remember them all. But I'm glad this judge went back and put it on the record. All right, so Hobson, attorney number 7. Thereafter, the court set a status conference for October 30th, 2023 at 10 a.m. and set a pretrial conference for November 28th at 9 a.m. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankowitz. The court further cautioned that if this becomes a problem or another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. So the court is like, I'm starting to take these attorneys seriously when they're complaining that there are irreconcilable differences. And what's the problem with all these things going on? There is clearly a common denominator, and that's Sarah. So I'm going to be looking a little bit closer at what your attorney might allege you're doing, a future attorney. So the court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make, like going to trial and or testifying. The court cautioned as to the defendant's unrealistic expectations regarding court-appointed counsel and reminded defendant of her right to retain private counsel. So, Ms. Boone, you are asking too much of your attorneys, and they have a right to defend you in the best way that they know how. That's their expertise. You should leave that to them. And by the way, you're always welcome to get your own attorney if you don't like any of the ones that the court's appointing you. That's what he's saying right there. Letter CC. On October 30th, 2023, the status conference was held. Hobson advised as to his conversations with the defendant in setting a status in January 2024. Finally, we're in this year. Thereafter, the court set a pretrial conference status as to the readiness for trial for January 16th, 2024 at 9 a.m. and the trial period beginning January 29th. Letter DD. On January 12th, 2024, Hobson filed the certain motion to continue waiver of presence and requested a 3-docket continuance. I have no idea what all that means. A motion to continue, I understand that. A waiver of presence, I'm assuming that's a waiver of Ms. Boone's presence, which I very highly doubt she would have signed or wanted with how much she's wanted to control this case. So I don't know what that is. Or a 3-docket continuance, whatever. Not a lawyer. If anybody knows, please let us know in the chat or the comments. That would be great. Because, yeah, I don't know. All right, so letter EE. On January 16th, 2024, the court addressed Hobson's motion to continue, granted same, set a pretrial conference for May 3rd at 9 a.m. and trial during the trial period of May 13th. So what is this, her third or fourth trial date now? I can't keep up with, I can't even keep track. We should have done tallies on both. FF. On February 1st, 2024, Hobson moved to withdraw due to irreconcilable differences, including but not limited to ethical considerations. Remember the lawyer number 2, the private lawyer, also said ethical concerns. So again, I wonder what that is. What do you guys think? Let us know in the comments what your ideas about this are and why she's gone through so many attorneys and what this is. There a strategy to going through the attorneys, or is she just scaring them all off with her aggressive way that she comes off with people? She's very abrasive in her letters, and you could tell, what attorney is going to want to defend a client who's calling them a dud and whatever else she said, I can't remember. All right, so GG. On February 9th, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis for withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and the defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. Well, there you have it right there. This is what the problem has been this whole time. So I'm going to read that again. Disagreements on legal strategy, on what can and cannot be done, a lack of resources, and the defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. So she's like, let's just say this or that or whatever, and it doesn't even make sense to her case. A non-viable legal position might be the battered wife syndrome, and we have lots of evidence of DV, for example. I don't know if that's true. I don't know. I cannot corroborate that, but that is something that I have heard rumors throughout, whatever. So I don't know. I'm not 100 on that, so don't quote me. As to a key substantive defense, Hobson advised that the retained and undisclosed expert is not keeping with what defendant okay, I think that's an error. So as to key substantive defense, Hobson advised that the retained undisclosed expert is not keeping with the defendant has in mind, with what the defendant has in mind. The court advised defendant that the court had received a letter from the defendant, a letter dated January 19th of this year. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, and Hobson, adversarial relationships, lack of satisfaction, and inability to meet the defendant's desires. So the court is seeing a pattern. The court, meaning this judge, Judge Kranick, is seeing there is a problem, and the problem is Sarah because she's the common denominator. These are all things that multiple attorneys now have said. Adversarial relationship, her not being satisfied with their ability to represent her, and not meeting her very, very high expectations. So the court found that all the defendant's relationships with all court-appointed counsel have deteriorated such that the defendant and the court-appointed counsel cannot work together. The court advised defendant, and although the defendant has a right to court-appointed counsel, that right is not unlimited. And that's a great point. You can't just keep going through attorney after attorney after attorney, which we've warned you after the first change, when you went to your second attorney, we warned you. We warned you again a couple times, few after several more had been withdrawn from your case. The court continually warns you you might end up representing yourself. You've been warned. All right, so the court found that all of the defendant's relationships deteriorated. The court advised the defendant that although the defendant has a right to court-appointed counsel, it's not unlimited. The court twice advised the defendant that the defendant may not be provided another court-appointed attorney, and that defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. So this is like his last stern warning to her. The court further advised the defendant about the dangers of self-representation due to the defendant's lack of legal training and knowledge. The defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman, or attorney number 8. So Cashman is the one who just withdrew recently. What does she say? So the court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of homicide, and is widely known. Listen to this. She is widely known to be able and willing to deal with and manage difficult clients. What does that say about Sarah Boone? Miss Patricia Cashman, public defender, gets assigned Sarah Boone. She has a reputation for working and willing to work well with difficult clients, clients that are difficult to manage, hard to deal with, very needy, wanting your attention constantly. 5 to 10 calls a day, I would say that's a difficult to manage client. The court set a status hearing for April 12th of this year. HH on April 12th, the status hearing was held. Cashman advised as to the depositions that had been set, the hiring of an expert, and a request for a future status date to address a trial date. The court set a status hearing for June 7th. On June 7th, 2022, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present for the hearing and was sworn. Therefore, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed by Cashman utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism and providing the court with letters dated June 4th and June 7th, which we just recently read, and both of which were filed on June 21st. On June 7th, the letter sets forth attacks on Cashman's professionalism and untruthful answers. The June 4th letter attacks Cashman's professionalism. Both letters confirm the defendant disconnecting and or walking out of meetings with Cashman. So there you have it. Excuse me. Almost inhaled my saliva there. All right, so Cashman advised to her efforts and time spent on the case for so far was 20 hours. Cashman addressed disagreements on legal strategy, including the defendant attaching importance to issues that may not be legally important. In riposte, defendant accused Cashman of lies and half-truths. On June 11th, Cashman moved to withdraw under Florida rule regulating the Florida bar. Substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client and irreconcilable differences, including but not limited to ethical considerations, have risen such that counsel can no longer provide representation. Again, with the ethical considerations. So what do you guys think the ethical considerations are? I wonder. It makes your mind go, You guys remember that like old, if you're old enough, that old 90s song, things that make you go, This is one of those things. Sarah Boone is one of those things that makes me go, hmm. All right, sorry, that's dating myself. KK. On June 28th, 2024, a hearing was held on Cashman's motion to withdraw. Cashman relied on Florida rule regulating the Florida bar and Schwab versus State as the basis for the withdrawal. LL at no time has the defendant refused to accept the services of any of her 7 appointed attorneys. So she's not refusing them. She's just very, very adversarial. We'll use their words, adversarial. All right, so here's the law. According to this judge, both the United States and the Florida constitutions agree that an indigent criminal defendant the right to assistance of appointed counsel, and N. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-representation in all criminal prosecutions. Okay, so you have a right to both. Forfeiture of right to counsel. I mean, you have a right to either having counsel represent you, or self-representation. Those are your two options. Forfeiture of right to counsel. The defendant in a criminal case can forfeit a right to court-appointed counsel. A forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself, even though he has not waived counsel and may still want legal representation. So this case law right here is key, and that verbiage right there is key because it's saying you haven't necessarily given up your right to counsel, but due to your actions and your behaviors, we are taking your right away. You have not taking it away, you have forfeited your right because of your actions and your behaviors. By not cooperating, by being too much of a difficult client, you forfeited your right to representation now. Forfeiture is a judicial response that adapts the course of the legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. So it is a judicial response, the judge, in response to what the defendant has been doing or saying, the engagement of misconduct, their unwillingness to cooperate, whatever it might be, the judge is stepping in and saying, I see what you're doing, Sarah, and I'm going to stop it here. I have the power to nip it in the bud and say, I'm taking your right to counsel away. You forfeited your right because you're the games that you're playing, basically, in layman's terms. QQ. As set forth above, defendant recalcitrance, and I knew this word was coming, but I didn't have it looked up. I wanted to give you guys a recalcitrance. Oops. Recalcitrant means having an obstinately uncooperative attitude toward authority or discipline. So having an obstinate blah, blah, blah. Words are hard sometimes, especially when you've been talking, your tongue gets tired. All right, so sorry, recalcitrant means having an obstinately uncooperative attitude toward authority or discipline. I would say that really does describe Sarah based on. Sorry, I'm like slipping and sliding in my seat here. I think that really does describe Sarah from what we've read in her notes and things like that. She can be a little bit recalcitrant. I don't know if I'm using it in the right tense, but recalcitrance. So, as set forth above, the defendant's recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact. See footnote 9 above. So even though she was already rid of Padilla, she's still talking about his professionalism or lack thereof. Of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Sorry about that. Mailman. It gets noisy here when I record and the mailman comes by. All right, so each of these attorneys were required to withdraw because of all of her BS. See United States versus Thomas, which found the misconduct in relationships with 4 attorneys, including verbal abuse, tearing up correspondence, refusal to cooperate in producing a witness list, hanging up on counsel during a telephone conversation, resulted in a forfeiture of right to counsel. That's this case, not necessarily Sarah, I think, where they're referring to someone else acting like that. I don't know. But it sounds very oddly specific to Sarah, so I'm not sure what that footnote is in reference to. But if she did all those things, yikes. All right, I think so. RR. It has become apparent to the court and defendant will not that the it has become apparent to the court that the defendant will not permit herself to be represented by anyone. SS. Additionally, the withdrawal of 8 different attorneys, 7 of which were court appointed, leads to a determination that the defendant has forfeited her right to counsel. See Watson versus State, receded from on other grounds by Waller versus State. TT. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. UU. As the court finds the defendant has forfeited the right to court-appointed counsel under Florida law, there is no obligation to conduct a Ferretta hearing or to otherwise warn a defendant of the dangers of proceedings pro se. Pro se means to represent yourself. So I don't know what a Ferretta hearing is. It must be, to again warn the defendant that, you shouldn't be representing yourself unless you know what you're doing. You're really getting in over your head type of warning. But that didn't need to take place because she's been warned so many times and she forfeited her right at this point in time. All right, so the waiver by conduct, VV. The court can find a waiver by conduct to the right to counsel. A waiver by conduct requires that a defendant be warned about the consequences of his conduct, including the risks of proceeding pro se, which this judge has done, other judges have done. She's been warned plenty of times. WW. On February 9th, 2024, the defendant was twice advised that another court-appointed attorney may not be provided. XX. On May 10th, 2022, the defendant was advised about the dangers of self-representation. She was actually warned multiple times, I believe. Why? On February 9th, the defendant was advised about the dangers of self-representation. There we go. ZZ, as of February 9th, the instant case has been continued 16 times. That means just that the date has been moved. This case has been moved forward 16 times. We should have had the trial 16 tries ago, but no, it just keeps getting continued. We're on AAA. As of June 26th, 2024, this case has been pending 4 years, 3 months, 5 days from the date of the filing of the information on March 23rd, 2020. Even taking into account the impact of the COVID-19 pandemic and the suspension of criminal trials, this case has been pending 1 year, 9 months, and 9 days. I think it's hilarious that he is pointing out the year, the month, the days. I'm sure it would be even funnier if he did seconds because that's what she was doing in her letters, like calling out, like it's been so many days and meetings with my attorney and da 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 da. So she would she would put time, like a timeline in her letters too. So it's kind of funny that the judge did it as well. Triple B, actions speak louder than words. I like that. I like that the judge put that in there because she may say, oh, no, 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 I don't want to lose my attorney, but I'm going to trash talk them in a public letter that I file publicly to the judge in my case. Actions speak louder than words. Although the defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing the defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought defendant's attention to the defendant's attention. There's so many errors in here. On May 10th, 2022. The defendant complains that Bankowitz and Hobson, two court-appointed attorneys, failed to meet and communicate, and when defendant is provided court-appointed counsel who will meet and communicate, like Cashman, the ways and means of meeting and communicating are unacceptable to the defendant. So she keeps pushing that goalpost. So she's saying in one sentence, well, this lawyer doesn't talk to me. They don't answer my calls. And then when they do answer her call, she's like, well, that's not how I want to talk to him. I want a Zoom call or something, like she's going to keep changing it. There are lots of people like this who play victimhood and nothing's ever right. Nothing's ever good enough. They're going to say, well, yes, my lawyer may talk to me once a day, but I want to talk to them 5 times a day, and that's not enough. So there's always going to be people in the world like this, and she really seems like the world owes her something. Like she's got a chip on her shoulder, she plays a victim, and everybody should just bow down to her, it seems. Sorry, Sarah, if that's wrong, I apologize. I'm not trying to like piss anybody off. It just seems that's how she appears so far from what we've seen. Triple C. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. Orders and adjudges as follows. 1. Cashman's motion to withdraw as counsel filed June 11th is granted. 2. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for costs to obtain transcripts of depositions for the 2 witnesses that Cashman deposed. Upon completion of the transcription of the depositions, the deposition transcripts shall be sent directly to defendant Sarah Boone. There you go, Sarah. Now you're going to get all the discovery because everything's going to you now. Send it to Sarah by Cashman at the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that the deposition transcripts were provided to the defendant, Sarah Boone, and such notice shall include a date sent and an address of the defendant, Sarah Boone. So basically, the defendant or the court just wants a receipt saying, yes, Judge, I, so and so, Cashman, hereby state that I certify that I sent this to Sarah Boone, whatever. That's all he wants is something on the record. All right, so 3, the defendant Sarah Boone has forfeited her right to court-appointed counsel. 4, alternatively, the defendant Sarah Boone has through waived her by her conduct her right to appointed counsel. So we want to make sure it's on the record through her own conduct. Her right to counsel has been waived. Nothing that anybody else did. It was all her own doing. Number 5, the trial management conference shall remain specifically set for Tuesday, September 24th. So it was already set for that date, Tuesday, December 24th at 1:30 p.m. This is a conference for their trial, pretrial conference. 6. This case shall remain specifically set for trial for the 2-week trial period beginning Monday, October 7th, and will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. So, counsel for the defendant, no more. You are pro se. I mean, if you were to get it's not excluding her from getting counsel, but if she were to get or if she were to hire someone privately, because it's not going to be a court appointed attorney, if she were to go out and hire her own attorney, they would have to adhere to that date. So they could prepare, I mean, it's not a whole lot of time to prepare, and it's not a whole lot of time for Sarah to prepare either, especially since she doesn't know the law. But either way, it's going to be her representing herself, or she can hire an outside private attorney, but I don't see that happening. And I don't know if anybody would want to take her case at this point, unless somebody does it pro se, or that's not what I meant, pro bono, particularly because they want to help her or something. But I don't think anybody's going to want to do that because of what we just read. All right, so no changes whatsoever. October 7th is when we're going to trial. Number 7, any and all pretrial motions in this case must be filed no later than the close of business on Monday, July 22nd. You guys have till July 22nd. Sarah, poor Sarah. You have until July 22nd, so you better get started. As I'm recording this, this is July 1st. You got 21 and a half days at this point to get it done. What are your pretrial motions? What are you gonna exclude, eliminate, or include? she doesn't even know what she's going to do. She's going to have to be studying in that prison library as in the law section for a while here, if they have one. I'm sure all jails should have a legal section, right? A law section in their libraries. I don't know. I don't know how good the resources are for them, but there's got to be something there to help them. So this is done and ordered in chambers at Orlando, Orange County, Florida, this 28th day of June. Michael S. Kranick, the Honorable Circuit Judge. And that, my friends, is how you become your own lawyer. You are so much of a nuisance to everybody around you that they all want to leave you. And then you get to be your own lawyer. Isn't that fun? I mean, this is going to be something to watch. A lot of people predicted this. I didn't know it was going to go to 8 attorneys, to be clear. Like, I never predicted that it would be that bad and that she would need to be her own lawyer. But here we are. And we get to watch it in October, hopefully. I don't know if it's going to be streamed, but I would assume. I know Florida does a lot of streaming, so I would think that they would stream this case. It's a big one. So hopefully Jose can get justice, his family can get justice, and justice can be served to Sarah. And if she is, if there is more to the story about the whole uh, battered wife syndrome or whatever it's called, um, if there is more to the story, I am open and willing to hear about it. But I still, having seen and heard the video of him screaming and asking for help, and then her, it's just so damning. It's so damning. So for her to even want to go to trial, she should just plead out. But she has a right to trial, and she has a right to represent herself. So it's either that or plead, if they even allow her to plead guilty. Just plead guilty, and then maybe this all goes away. But I don't think she's going to do that. What do you guys think? Would she ever admit guilt? Probably not. I think she's going to be those ones that to her dying day, she's going to say, I didn't do it. We were just playing. We were playing hide and seek in a suitcase as adults. Doesn't make any sense, but that was her excuse when all was said and done, and she found him the next morning. So let me know in the comments below what you guys think of Sarah representing herself. It's going to be a wild ride, and I look forward to watching it and sharing information with you guys as we do. So please hit that like button. Don't forget to be subscribed so that if more information comes out regarding Sarah's case and others like it, I can inform you about it. So thank you guys so much for watching. I really appreciate it. Hit that like button on your way out, please. And I will see you guys in the next one. Take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.